Hello, my name is David Anton, and this is a short and informal blog on the issue of relocation of minor children. What is it? It's when two parents, after a divorce or a paternity action, are left with the responsibility and the privilege of raising minor children, and one of them, typically the one with majority time sharing, who has most of the time with the children or child, wants to leave the area. And that is a very difficult, very emotional, and in our transient society today, very common issue. We're facing a lot of those in my law firm today. This is a transient society. People sometimes want to move away for many reasons. The two typical ones that come to mind are changes in employment to better oneself, or a development of a relationship where perhaps one wants to leave to become married. Just two of the issues though, two of the possibilities. So what is a relocation? Moving across the street is not a relocation. It is defined by a number of miles. You take where you lived at the time of the time-sharing agreement or court order. If you then want to move more than 50 miles away from that location, it is deemed a relocation. So it could technically just be to the next county, if it's a large county, or it might even be to another country, or anything in the middle. So what happens in that case? Who is going to have the child accompany them during their relocation? Will the child stay behind with the remaining parent, or will the child move with the relocating parent? Well, how do you deal with something like this? Well, there's two general ways. One is the uncontested way, and the other is the contested way. Uncontested, of course, being much simpler. The easiest way is by agreement. And typically these agreements are reached, if they are reached, with certain accommodations made to the party that allows for the relocation. Let's say the child does move 400 miles away. The parent that's left behind typically negotiates fewer, though larger, time-sharing sessions with his or her minor child. For example, you might end up with more time during the summer, more time during the winter break from school, more time during the spring break from school, and so on and so forth. So fewer but larger amounts of visitation. Does this fully replace what you lose by seeing a child every week? No, it doesn't, but sometimes it's the best you can do. And you also nowadays have other options to visit with your child electronically, such as webcams or Skype, where you can actually talk to your child with a screen and you can both see each other, which of course is no full replacement for being there, but it is helpful. Another area for concession is that of child support. Obviously, when you live far apart, there are costs involved in relocation. Child support can sometimes be knocked down to take advantage of or to compensate for these additional costs, and in order to also just give some other types of relief to the party that remains behind. So those are the two big areas of concessions that sometimes happen when you have an agreement to relocate. But what happens if you can't agree and you have a contested relocation? First, let's talk very briefly about the procedure. The party that wants to relocate has to first file a petition for relocation with the court system. That petition is then served upon the other party, delivered to them by a private process server or sheriff. They then have 20 days to respond objecting to the relocation, and if they don't, it is presumed that they do not object to the relocation. But if they do file a response objecting to the relocation, the parties then have to go ahead and fight it out in the court system to determine if the relocation will be allowed and what will be the terms. Sometimes parties move without, following the procedure, and they take the child with them. What happens if that happens? The court has certain options about what to do should the other side complain. One is the court, and quite frequently will, demand the return of the relocating party with the child. Number two, the court can find that the moving party is in contempt and issue all sorts of remedies that can be very damaging. Thirdly, should the remaining party move to modify time sharing so that the child will primarily live with them, as an example, that movement, without getting the court's authority is a factor that can be used against the moving party. There's also, of course, the sanction of attorney's fees and court costs. Now, sometimes these relocations are very time sensitive. Typically, when an employer offers you a job, they don't say this job offer is open for the next 6 months or a year. So time delayed in determining a relocation issue oftentimes would end up in the need for relocation being eliminated. So the courts have built in a procedure which is provided by the Florida statutes that makes the scheduling of a hearing in a relocation expedited, made quicker. So the courts are supposed to schedule a final hearing in relocation no more than 90 days after somebody demands the hearing. Sometimes even 90 days is too long. Many times that's the case with employment changes, and you can actually get a temporary order allowing or denying relocation with only 30 days notice. Now, a temporary order is not a guaranteed order. They can either deny the request for relocation, or if they think it's likely to prevail, allow for the relocation on a temporary basis pending a full final hearing on the matter. And the fact that the court has allowed a temporary relocation is not considered in the final decision. Another reason sometimes to request an urgent hearing is because children need to be enrolled in school. And if, for example, relocations take place during the summer, you want to make sure they can enroll in school the next year in the school they're going to stay at. So really, sometimes justice delayed is justice denied, but that concept is built into the rules. Now, what does the court consider when one party wants to relocate? Well, of course, life is very complicated and has a lot of factors involved in it, but there are certain reoccurring factors that the courts do customarily consider, in addition to many, many numerous other factors that might be involved in a particular group's or family's situation. Factor number one, the reasons, the motivation for the relocation. Typical motivations are a change for better employment, that's recognized, a change because a party wants to be remarried to someone who must live in a place that's far away, and that's more and more common with computer dating and so on and so forth nowadays. One of the reasons that would be a bad reason to relocate, those being the two typical ones, but this one also is typical, is a desire for one parent simply to get away from the other parent or their family. That usually is a very bad justification for relocation. So factor one is motivation. Number two, where do you want to relocate to? Is it only 60 miles away? Is it all the way across the country, such as in California when you live in Florida? Or is it in Germany? You see a lot of those in military divorces also. So how far away you want to relocate is a big factor. It's much easier to prevail on a relocation that's 60 miles away than it is if it's 6,000 miles away. Another factor that is considered is the economics. When you have relocation, there is an increase in visitation costs. If somebody moves 4 states away, there's transportation, sometimes there's hotel, if the person wants to come back and see their child. So economics plays a picture. Well, sometimes economics can be dealt with through a change in child support, or economics can be dealt with by the relocating party who got the better job, paying for all of the expenses of relocation, travel and visitation or timesharing out of their own paycheck, so to speak. So that can be dealt with that way sometimes. But as we all know, many families have no extra money to spend on transportation, and thus if one parent moves 1,000 miles away and you're earning $10 an hour, there really is no way, or it's very difficult to exercise any time sharing. So that kind of economics really is a big factor in some cases. So the richer you are, the more easily it is to implement a rational relocation alternative time-sharing type plan. Another big factor to be considered is, and this is one of the biggest, The parent that does not relocate, how much time and how much involvement have they had in the child's life? If you're requesting to relocate a child and the parent that's left behind sees that child 45 or 40% of the time and is consistently a major part of that child's life, it is harder to prevail in a relocation than if the parent left behind only sees the child once a month for perhaps one overnight or never sees the child. Then relocation is not as big a deal because the parent left behind never had that big of a role in the child's life anyway. A last factor I'll discuss, and there are many, and this one is a lesser factor compared to the three I've already mentioned, is child support. The party that's staying behind, have they ever supported the minor child as ordered by the court, or have they been consistently involved in that support? Now, one more thing I wanted to make sure we all understood is that no court has the ability to tell an adult that they can't relocate in these conditions. Basically, it is the question of relocation of the minor child. Anytime a parent wants to relocate, they have a constitutional right to do that. What they don't have a constitutional right to do is to take a minor child with them when the other legal parent of the child doesn't want the child to leave. Anyway, that's the end of my relocation blog. We are at my law firm doing a lot of these relocations nowadays, especially during the summer months. So if you have any questions about relocation or have any concerns or want to get a case analysis, please feel free to call us at the Anton Legal Group. My name is David Anton. Our phone number is 813-443-5249, and thank you for listening to our informal blog on relocation of minor children in Florida.